Good morning all. The clock is about to strike 9 a.m., so I will call to order the executive session of the State Ethics Commission this 31st day of January, and state that pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to the said executive session or at the next meeting thereafter. An executive teleconference meeting was held on January 10th, 2012 to review matters that are by statute confidential, and they included the review of and consideration of applications for 90-day extensions of investigations filed by the Investigative Division. And an executive session was also held on January 30th, 2012 to review matters that are by statute confidential, and they included a review of completed investigations for the purpose of issuing final adjudications, the consideration of the assigned reviewing commissioner's recommendation to terminate certain preliminary inquiries, the review and consideration of applications for 90-day extensions of the investigations filed by the Investigation Division, and a review of pending litigation, all of which would be confidential, but the subject matters are announced at this public meeting. The executive session also included a consultation with the Commission's Chief Counsel regarding confidential legal advice involving the de minimis exception to the term conflict of interest. Also, pursuant to the Public Official and Employees Ethics Law, Act 170 of 1978, as amended by Act 9 1989 of June 26, 1989, and amended again by Act 93 of 1998, the State Ethics Commission is specifically mandated to hold at least 2 public hearings, each of which shall be held in Harrisburg, the capital, and at least one shall be held in a location other than Harrisburg to specifically seek input from persons and organizations who represent any individuals subject to the provisions of this Act and from any other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive the input or testimony of said individuals pursuant to the provisions of the law. As our previously published notice has indicated, the Commission will request that copies of any statement be presented to them. The individuals presenting statements before the Commission will be allocated 15 minutes in order to complete their statements. Statements shall be uninterrupted, except that such statements may be interrupted or terminated by the presiding officer if it is determined that such statements are impertinent, scandalous, or otherwise improper. And with that, we'll move to our agenda, which has been distributed to all commissioners. Number 1 on the agenda is the approval of the September 27, 2011 public meeting minutes. All those minutes have been distributed to all those commissioners, and I ask if there are any additions, corrections, or amendments to those minutes.
I'll move their adoption.
There being none, there is a motion to adopt the minutes. Is there a second to the motion?
Second.
Any objections? There being none, all those in favor kindly respond by saying aye.
Aye.
Aye. Any opposed? And there are none, so the minutes are approved. With that, we'll move into our stated agenda, and first addressing civil penalty orders. And most of these are consents, and for the first number of them, I think Commissioner Bolger, you have reviewed those along with the rest of the commissioners?
I think Commissioner Bergen has those.
Why did I see the B and said Bolger instead of Bergen? My
I do,
apologies,
that's
Commissioner
okay.
Bergen.
Thank you, Mr.
I
Chair.
don't know why.
I
You
have
the
one.
last one.
I have one.
There are 9 administrative penalty cases with proposed consent agreements for our consideration. The following 5 respondents failed to timely file 1 or more quarterly expense reports in their capacities as registered principals: Salus University, Synagro Technologies, Inc., Barnes & Noble College Booksellers, Metropolitan Career Center, and Food for All, Inc. For the following 4 respondents, a lobbyist registration statement was filed by or on behalf of the respondent, but the respondent failed to pay the required registration fee or file the required photograph or both. Donald R. Pickle, Jr., Dave Dunmeyer, Teresa Bolger, and Mary Scholl. In each case, the parties are in agreement that the respondent's transgressions of the lobbying disclosure law were negligent. Each respondent has already paid the agreed-upon administrative penalty. The respondents who are principals have already filed their delinquent expense reports. 2 respondents who are lobbyists, specifically Mr. Dunmeyer and Ms. Scholl, have already filed their photographs. Mr. Pickle and Ms. Bolger may still need to file their photographs, and Mr. Pickle may still need to pay his registration fee. Based upon my review of the facts, I am of the opinion that the consent agreements are proper dispositions for the respective cases. I would like to make the following motion. I move that the Commission approve the consent agreements by each of the following respondents and the investigative division and impose the following administrative penalties. As to Salish University, an administrative penalty in the amount of $5,740 for its delinquent expense report for the first quarter of 2011. As to Synagro Technologies, Inc., an administrative penalty in the amount of $20,900 for its delinquent expense reports for the fourth quarter of 2010 and the first quarter of 2011. As to Barnes & Noble College Booksellers, an administrative penalty in the amount of $5,705 for its delinquent expense report for the first quarter of 2011. As to Metropolitan Career Center, an administrative penalty in the amount of $1,584 for its delinquent expense report for the first quarter of 2011. And as to Food for All, Inc., an administrative penalty in the amount of $1,548 for its delinquent expense report for the fourth quarter of 2010 and the first quarter of 2011. The orders for Metropolitan Career Center and Food for All, Inc. shall direct them to fulfill their agreements to refrain from any and all lobbying activities in Pennsylvania until December 31st, 2014. I further move that this Commission approve the consent agreement submitted by each of the following respondents and the investigative division and impose the following administrative penalties. As to Donald R. Pickle, Jr., an administrative penalty in the amount of $475 for failing to timely pay his registration fee and submit his photograph for his lobbyist registration statement filed January 24th, 2010. As to Dave Dubmeyer, an administrative penalty in the amount of $3,640 for failing to timely submit his photograph for his lobbyist registration statement filed October 30th, 2009. As to Teresa Bolger, an administrative penalty in the amount of $480 for failing to timely submit her photograph for her lobbyist registration statement filed December 9, 2009. As to Mary Scholl, an administrative penalty in the amount of $305 for failing to timely submit her photograph for her lobbyist registration statement filed March 1st, 2011. The order for Donald R. Pickle, Jr. shall direct him to pay his registration fee and file his photograph to the extent he has not already done so. The order for Teresa J. Bolger shall direct her to file her photograph to the extent she has already done so. I move that this Commission adopt the consents as agreed upon.
There is a motion on the floor. Is there a second to the motion?
Second.
All of the commissioners have received in detail all of the facts and circumstances surrounding these consent orders. So I would ask, are there any questions, comments, concerns?
Yeah.
Yes, Commissioner Bolger.
I'm just curious, does the Department of State send over those violations to us?
No, what we do is our staff from the investigative division, after a certain period of time, when the quarter's over, compares the registered principals at the Department of State and lobbyists to the principals who have filed expense reports. So they have the information at the Department of State, but we go, we ask for it, and then we take the lists internally and we do the comparisons as to who is registered and who is not filed, and then we compare the two and we come up with a list of non-filers or people who have not filed their expense reports or have not filed their photo or have not paid the fee. And what we do is we send out the first notice letter and we give them the opportunity to comply. If they comply within a given period of time, then nothing further happens. If they do not comply after the first notice letter, then we actually file a notice of alleged noncompliance, which is after that the process takes place and they either proceed before the Commission in terms of a hearing or they agree to settle the matter.
Which in this case, they did agree.
Which in the cases you just dealt with, they did agree.
Okay. And question number 2, Mr. Chairman. I quickly added these up, roughly about $35,000. Does that money go into our budget or into the Treasury?
No, it goes into the Commonwealth General Fund.
And there's no credit against our budget.
No, we would not be able to take fines back. The law would prohibit the commission from assessing a fine and then adding it to its own budget. It would have to go into the general fund, and we get no real credit from it when they consider our budget later in the year. It's just the way the process works.
Okay.
It goes into the Commonwealth's general fund,
Which they control.
which the state controls that,
Okay.
basically.
Thank you, Mr. Chairman.
You're very welcome, and we pointed out at the hearing before the government committee that we do get so much money in fines, and that should be credited, if not by dollar, at least of what we're doing to enhance the budget of the Commonwealth of Pennsylvania. Are there any other questions or comments? If not, all those in favor kindly respond by saying aye.
Aye.
Are there any opposed? There being none, then the motion carries. With that, we'll move into civil penalty orders by default. Commissioner Colafello?
Thank you, Mr. Chairman.
Okay. What about McElhatton? We'll go back and we'll do McElhatton. No, we changed that. So McElhatton was one where we were going to address it, but I understand there has been a consent decree entered into since then, and in order to have it made part of the record, I'll ask Commissioner Bolger if you would address the McElhatton matter first before we go into the civil penalty orders.
Consent. Okay. As Chairman Fryman said, there's one additional proposed, it's a consent agreement for our consideration. The matter involves respondent Daniel McElhatton, who filed a lobbyist registration statement on January 12, 2011, but failed to timely file the required photograph. The parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. Respondent has paid the agreed upon administrative penalty and submitted his photograph to the investigative division. Based on my review of the facts, I am of the opinion that the consent agreement is a proper disposition of this case, and I would like to make the following motion to adopt this consent agreement. I move that this commission approve the consent agreement submitted by respondent Daniel McElhatton in the investigative division and impose an administrative penalty as the respondent McElhatton in the amount of $695 for failing to timely submit his photograph for his lobbyist registration statement filed January 12, 2011. That's my motion, Mr. Chairman.
Thank you. Is there a second to the motion?
Second?
And there is a second to the motion. I would note for the record that the consent decree, or consent agreement was distributed to all the commissioners as a substitute matter in the agenda before this meeting, so that we all had a chance to review it as well. Are there any concerns, comments in regard to the McElhatton matter? There being none, all those in favor, please say aye.
Aye.
Any opposed? There being none, that order is entered as well. I would note that Mark Corrigan, the Secretary to the Senate, is with us this morning. If the information I received is correct, you're going to be leaving that post?
Eventually, I think so, yeah.
Well, eventually, we won't wait till eventually. We say now, we'll wish you well.
Thank you.
You're very welcome. Going on to the now civil penalty orders, Commissioner Colafello.
Thank you, Mr. Chairman. There is one default administrative penalty case for our consideration. This case involves respondent Thomas J. Healy II. Respondent Healy did not file an answer, appeal, or other request for a hearing as to the notice of alleged non-compliance. Following review, it is my opinion that the Commission should impose a maximum administrative penalty as to respondent Healy. The administrative penalty would be $50 per day for each day after November 21st, 2009. That respondent Healy has failed or continues to fail to pay the $100 registration fee and or submit a recent photograph to the Department of State for 2009-2010 registration period. There are no mitigating circumstances of record. Additionally, respondent Healy should be directed to submit the required photograph and pay the registration fee. Based upon my review of the facts, I would like to make the following motion. I move that this commission levy a maximum administrative penalty against respondent Thomas J. Healy II in the amount of $50 per day for each day after November 21st, 2009, that he has failed or continues to fail to pay the $100 registration fee in order to submit a recent photograph to the Department of State for the 2009-2010 registration period. The order for responding, Healy shall direct him to pay his registration fee and submit his photograph to the Department of State by no later than the 30th day after the mailing date of the order, to the extent he has not already done so. Based on this, I move that this commission adopt this penalty order.
The motion is on the floor. Is there a second to the motion?
Second.
The floor is open for any concerns, comments, amendments, questions. There being none, all those in favor of the motion kindly respond by saying aye.
Aye.
Or on the contrary minded, and there being none, the motion carries as well. Moving on to some of the ethics matters, the Alexander case. Commissioner Wolf and Commissioner Bolger have both looked at that intently, as have all of us who have received the material, but since he is present, I'd ask Commissioner Bolger if you would address that matter.
Okay, thank you, Mr. Chairman. The facts pertaining to this advisory request may be summarized as follows. The requester is Pennsylvania Secretary of Public Welfare, Gary D. Alexander. On July 14, 2011, in his private capacity, Secretary Alexander organized a company in Rhode Island named Smart Alex Consulting, LLC, which I shall refer to as the company. The company was organized for the purpose of name reservation. The company was formed as an investment consulting firm. The company currently has no financial transactions and is inactive. Based upon the submitted facts, Secretary Alexander seeks guidance as to whether the Ethics Act would impose any prohibitions or restrictions upon him with regard to engaging in private business activities related to the company. Mr. Chairman, I would suggest this is an appropriate time for any interested parties to speak on this matter if they would like to do so.
And the floor is open. Is there anyone present who wishes to address this matter before the commission? Seeing or hearing none, Commissioner Bolger.
Mr. Chairman, I have reviewed the facts and the relevant statutory provisions. Based upon the relevant statutory provisions, as well as commission precedent, it is my view that the Ethics Act would not preclude Secretary Alexander from engaging in private business activities related to the company, subject to the condition that in his public position he would comply with all applicable provisions of Section 1103 of the Ethics Act. The opinion that we issued to Secretary Alexander should explain Sections 1103A and 1103J of the Ethics Act, which pertain to conflicts of interest and voting conflicts. For example, the Commission has held that pursuant to Section 1103A of the Ethics Act, a public official or a public employee may not use governmental facilities such as governmental telephones, postage, equipment, research material, or other property or governmental personnel to conduct private business activities. The Commission has also held that a public official or public employee may not, in whole or in part, use the public position to solicit business opportunities for himself or for a business with which he is associated. The Commission has held that in each instance of a conflict of interest, a public official or a public employee is required to abstain from participation, which includes voting, unless one of the statutory exceptions of Section 1103J of the Ethics Act is applicable. Section 1103J also imposes disclosure requirements as to voting conflicts. The opinion should also mention Sections 1103B and 1103C of the Ethics Act, which prohibit improper influence as to the public official or public employee. This is not to suggest that the secretary would engage in such conduct. Rather, those sections should be referenced for purposes of providing a complete response to this advisory request. Given this analysis, Mr. Chairman, and comments, I would like to make the following motion. As Pennsylvania's Secretary of Public Welfare, Gary D. Alexander, is a public official and an executive level state employee subject to the Ethics Act. Under the submitted facts, the Ethics Act would not preclude Secretary Alexander from engaging in private business activities related to the company he has organized in Rhode Island, namely Smart Alex Consulting LLC, subject to the condition that in this public position, he would comply with all applicable provisions of Section 1103 of the Ethics Act. That is my motion, Mr. Chairman.
That is the motion. Is there a second to the motion? And there is a second to the motion. Commissioner Volk, do you have any comments, or has it all been presented?
No, sir, I do not have anything else to add.
Thank you very much. Questions, comments, concerns from any commissioner in regard to the Alexander matter? Seeing or hearing none, all those in favor of the motion as presented, kindly respond by saying aye.
Aye.
Are there any opposed? There being none, the motion carries. Thank you, Commissioner Folger. We'll move on to the civil penalties, both as to the consent orders and the default matters. Commissioner McCurdy, I believe you have reviewed those for all of them.
Thank you, Mr. Chairman. There are two civil penalty cases with proposed consent agreements that are now before the Commission for decision. These cases involve respondents Alan Henderson and William Lawler. Parties have submitted consent agreements proposing that the Commission find that the respective respondent failed to timely file one or more complete and accurate statements of financial interest and impose one or more civil penalties. Respondents have already satisfied the terms of the consent agreement. Respondents have paid the recommended civil penalties pursuant to the respective consent agreements and filed the delinquent forms. Based upon my review of the facts, I'm of the opinion that these consent agreements are consistent with Commission precedent and are proper dispositions for these cases. Further, based upon my analysis and comments, I'd like to make the following motion. I move that this Commission approve the consent agreements submitted by each of the following respondents and the investigative division imposing civil penalties for failure to timely file complete and accurate statements of financial interest for the respective calendar years as follows. Number one, Alan Henderson for calendar year 2008 or 2009, $75, and William Lawler for calendar year 2009, $200. That's my motion.
The motion is presented as a second to the motion, and that's been seconded by Commissioner Colafello. Comments, concerns, questions, objections? Anything further on those? It's easy when they are consent agreements. All those in favor of the motion as presented, kindly respond by saying aye. Aye. Any negative-minded? And there being none, that motion carries as well. And we'll move into the civil penalties, and I think Commissioner McCurdy, you also have reviewed those as well.
I do, Mr. Chairman, and these are 5 civil penalty default cases. They're now before this Commission for decision. The cases involve respondents Carl R. Green, J.S. Keever III, Joseph Yost, Tim Kephart, and Tanya Williams Bell. These respondents did not file timely answers or respond to the civil penalty proceeding. Following my review, it's my opinion that as to each of these respondents, the Commission should levy a maximum civil penalty of $250 for each delinquent or deficient statement of financial interest. For respondent Green, the total civil penalty liability would be $1,500. For respondent Keever, the total penalty liability would be $500. As respondents Yost, Kephart, and Williams Bell, the total civil penalty liability would be $250 per respondent. In my opinion, that the Commission should also order all of these respondents to file an amend their statements of financial interest. There is nothing of record that would constitute a defense or excuse for any non-compliance. Based upon my analysis and the comments I've made, I'd like to make the following motion.
Please.
A motion for default cases. I move that this commission levy civil penalties against the following respondents totaling the following amounts for failing to file statements of financial interest or for filing deficient statements of financial interest for the respective calendar years contrary to the Ethics Act. Number one, Carl R. Green, $1,500 for calendar years 2004, 2005, 2006, 2007, 2008, and 2009. J.S. Keeler III, $500 for calendar year 2008 and 2009. 3. Joseph Yost, $250 for calendar year 2010. 4. Kim Kephart, $250 for calendar year 2009. And number 5, Daniel Williams Bell, $250 for calendar year 2010. Further, these respondents shall be ordered to file an amend their statements of financial interest as appropriate for the years stated within 30 days of issuance of this commission's orders. That's my motion.
That is the motion. Is there a second to the motion?
Second.
And there is a second to the motion. The floor is open for any comments, concerns, questions, amendments. Hearing or seeing none, all those in favor of the motion, please say aye.
Aye.
Are there any negative-minded? And there being none, the motion is carried. Thank you, Commissioner McCurdy. There are certain administrative matters that we are obliged to undertake, and I would call on our Executive Director, Mr. Contino. First, some cases when there are penalties imposed, agreements are reached that there may be a payout to make it easier for the respondent to pay his obligation and making sure that we collect the appropriate funds for the Commonwealth. Mr. Contino, you want to comment on any of those?
Yes, Mr. Barry Friedland, who was a member of the York City School Board of Directors, you issued an order at your last executive meeting, finding violation of the law, accepting a consent agreement, and Mr. Friedland had agreed to pay a fine of $500, but to also provide $10,000 in free services from his company to the school district in the form of restitution for the gain he had obtained. The services have been provided, so that part of it, the majority part of the penalty has already been taken care of, the $10,000. He does have a small $500 fine left to pay. He's asked if he could make that payment over 5 months, $100 a month. The administration for the commission has agreed to it, unless the commission has some problem with that.
There is no need for a motion for approval, but it is important and necessary that we decided some time ago that we and the public be made aware of any of these payment schedules. Are there any questions concerning the one expressed by Executive Director Contino? If not, any others? John?
No, that's it for this meeting.
Thank you very much. There is a bill pending in the House, which has been entitled Bill Number 1200, the Public Integrity Commission Bill. Are there any comments on that?
Just an update that, as most of the commissioners are already aware from individual conversations, Mr. Fryman testified before the House Judiciary Committee on the Public Integrity Commission bill. Mr. Bulger and Mr. Colafello were also present to answer questions of the committee. Since that point in time, the committee has not moved on the bill, although the commission has provided relevant information both to Chairman Metcalf, who's was the prime holder of the Public Integrity Commission hearings, and we also provided the same information to State Representative Babette Josephs, who's the minority chair of the committee, in terms of the activities of the commission over probably the last 10 years, the accomplishments of the commissions, plus approximately 29 suggested amendments that the commission believes would enhance the ability of the Ethics Commission to do its job rather than initiating an entire new bureaucracy. Since that point in time, since provision of those documents, nothing else has happened with House Bill 1200. That's pretty much it.
Anybody require any additional information or have any questions concerning the status of that bill or the actions of this commission or its executive director? There being none, we can move on to the annual event of election of officers. Mr. McCurdy?
Mr. Chairman, I would like to make a motion at this time that the nomination of yourself as our chairman and Mr. Bulger as co-chairman, and I also would like to move that the nominations be closed and that I'm looking for seconds.
I'll second.
I think we have 2 seconds.
Mr. McCurdy, if you would call, since I'm the nominee, I would rather you handle this vote.
Are the members ready to vote? All those present signify by saying aye to the proposal.
Aye.
I think it carries, Mr. Chairman.
Thank you very much. I certainly appreciate the confidence that you've expressed in me. I will continue and pledge to hold this office with the same devotion, integrity, and commitment that all of you have, and that all of you have expressed during our term together. So thank you very much. With that, our regular agenda is concluded. but
Excuse me,
Yes.
and I did your remarks and thank the fellow commissioners for their confidence in me also.
Can we now close our campaign committees?
Right, we'll take down all of the signs and
Our super PAC worked.
with that, the agenda items have been concluded, with the exception of any comments from the public. First, I'd ask Claire, do you receive any notice from anyone that wishes to address?
I did not.
No one has requested to address the commission, and there have been no written statements handed to us, but I would not let this moment go by without asking, is there anyone in the audience that has any matter which they wish to bring before the commission? Seeing or hearing none, the floor is open for a motion to adjourn.
So moved.
And it's been moved and second. All those in favor? Since there are no objections, thank you all very much. We're off the record.